Good afternoon. I call this video Seduction and Alienation of Affection No More. But before I get to that, I really wanted to convey the point that in terms of someone going through a difficult divorce, if you want to tell your story and you expect someone to listen to your story, you really need to consider the process that you choose. In a collaborative law or mediation process, there will be one or more people there to listen to you and hear your story. But in litigation, you have to understand that the importance of a therapist, because your attorney is not a mental health professional, the judge is not a mental health professional, and your therapist can help you get through the divorce emotionally. So it's important to recognize that and accept the fact early on that a judge is not going to necessarily be there to listen to everything that happened during your marriage. In regard to seduction and alienation of affection no more, from an historical aspect, we do have laws in New York that deal with certain causes of action. So up to the 1930s, people could bring claims for seduction, alienation of affection, criminal conversation, and breach of promise to marry. But in the 1930s, at about the same time that common law marriage was abolished in New York, those causes of action were also abolished. So you could no longer bring a claim for seduction, alienation of affection, breach of promise to marry. And so I did have a case about 20 years ago where the other side mistakenly brought one of those causes of action. And the reality is that the courts simply don't have enough time to listen to every factual allegation. And apparently in the 1800s and early 1900s in New York, there were many, many cases like this. And the New York State legislature decided that they had to eliminate these causes of action. Otherwise, the courts would continue to be overwhelmed and simply would not be able to function. And they actually went a step further. They made it a felony for an attorney to bring a claim with one of these causes of action. So they really put an exclamation point upon abolishing these causes of action. So getting back to my original point, I really just want to emphasize the fact that the courts really do not have the time. They're limited in what they can do and what they can listen to. So if you have an expectation in a litigated divorce that a judge at some point before a trial is going to sit and give you the opportunity to tell your story, it's really unlikely. And you should have an awareness of that. And the sooner that someone accepts that, the sooner that you can focus on getting your case settled and hopefully move on. So certainly if you have any questions, please contact me, Ken Novenstern at Fredman, Baken and Novenstern LLP, and I look forward to talking to you. Take care.